Please be seated. The sitting is open. The court meets today to hear the first round of oral argument of the Russian Federation. For reasons duly made known to me, Judge Abraham is unable to be present on the bench today. I now give the floor to His Excellency Mr. Alexander V. Shulgin, agent of the Russian Federation. You have the floor, Excellency.
Madam President, distinguished members of the Court, it is for me a great honor and a privilege to appear before this Court on behalf of the Russian Federation. Russia has tremendous respect for the International Court of Justice as the principal judicial organ of the United Nations, and which represents different legal traditions and systems from around the world. Russia counts on the peaceful settlement of disputes in accordance with the United Nations Charter, including through a fair and impartial judicial procedure. We are firmly convinced that justice must be rendered openly and independently of political considerations. Indeed, truth must be expressed for justice to be done. It is in this spirit that my country has engaged in good faith in these judicial proceedings concerning two major multilateral conventions: the International Convention for the Suppression of the Financing of Terrorism, ICSFT, and the International Convention on the Elimination of All Forms of Racial Discrimination, CERD. Unfortunately, it is not always easy to establish the truth. Today, in the information era, truth sometimes seems to be obvious and easily accessible, whereas in actual fact, it is clouded by a political fog created by information campaigns that are propagated and dominated by the most powerful states and media companies. This makes the judicial task even more difficult than it was before. Madam President, distinguished members of the Court, we have heard the applicant during these hearings, and we have no doubts as to its desire to assume the role of accuser while trying to set itself forward as a protector of the peoples of the Crimea against discrimination, while accusing the Donetsk and Lugansk People's Republics of being a terrorist organization supposedly financed by Russia. Nothing, however, could be further removed from the truth. Kiev has no moral authority allowing it to put forward such accusations. That regime came to power following a violent coup d'etat in 2014. They arrived on the shoulders of nationalists, the direct descendants of Nazi collaborators from the Second World War. The current Ukrainian government openly acclaims and celebrates Nazi war criminals as Ukrainian heroes. The neo-Nazi groups on whose shoulders the current Kiev regime rests began by encouraging the armed revolts in western Ukraine. And this was well before the events that occurred in the east. They continued with the violence at the Maidan in Kiev, the effect of which was to overturn both the president and the legitimate government of Ukraine. As a result, a new government of victors, in inverted commas, including neo-Nazis, leaders of the Maidan, and their collaborators in key positions in charge of the armed forces, the police, and propaganda, came to power. They continued to spread terror throughout the entire country, killing opposition leaders, politicians, journalists, and ordinary citizens who quite simply dared to express their disagreement. Anyone who opposed, mainly in the eastern regions, in the Donbass, the answer given to these was a massive armed attack by the regime, and at the same time that same regime qualified them as terrorists in order to justify such brutal repression. For a period of 7 years, since the spring of 2014, that regime has decimated Donbass. Shelling, bombing, and daily killings have caused thousands of deaths and thousands of civilians injured, many of whom were children. The soldiers from Kiev and the neo-Nazi battalions have used civilians as human shields in order to protect themselves against the reprisals of the Donbass forces. What Ukraine is now seeking is a decision by your court that would allow it to treat the citizens of Donbass who are fighting for survival as, in inverted commas, equal to terrorists. But it is clear, it is generally acknowledged that the situation in Donbass was a bloody armed conflict between the Kiev regime and the Donetsk and Luhansk republics. A conflict governed by humanitarian law. Aside from Ukraine, nobody has ever considered that these republics were terrorist organizations. Madam President, distinguished members of the court, at the provisional measures stage, the court found that the arguments of Ukraine concerning the financing of terrorism were not plausible, given that Ukraine failed to demonstrate that the acts that it was referring to could even be considered as offences within the meaning of Article 2 of the ICSFT. At the judicial stage and at the stage of admissibility, the court decided to postpone its examination of the main arguments of Russia as to the merits, in particular those concerning intention and knowledge. Today, we are going to show you how Ukraine's claims are not just implausible. What is more, they are based on flawed interpretations of law and contradict even elementary common sense, and they are based either on fake factual evidence or contradict Ukraine's own position. The same can be said of Ukraine's allegations concerning a so-called systemic campaign of racial discrimination, I quote, against the Ukrainians and Tatars of Crimea. Ukraine has committed violations of Crimeans' rights, and this has been recorded over a period of years, nonetheless sets itself up as their protector today. It is all the more hypocritical because Kiev, together with the Mejlis, has established a blockade of Crimea, cutting off the peninsula from access to water, food, electricity, medication and other essentials to the detriment of the population. What is more, the members of the Mejlis set off bombs in order to destroy the energy lines leading to Crimea, thus depriving the entire population of Crimea of electricity. Ukraine is now looking for flaws in the educational system of Crimea, while approving the ban not only on education in the Russian language beyond elementary school, but also use of the Russian language in the media and in public life, notwithstanding the fact that the Russian language in Ukraine, contrary to the Ukrainian language in Crimea, is a language in daily use for the majority of the population. The actions taken by the regime in Kiev, contrary to the legal effervescence of its council, show that our opponents have no real interest in the well-being of Crimeans, nor for the struggle against their so-called, and I quote, discrimination. Kiev's real objective is not to fight against discrimination, but to challenge the status of Crimea, which is not at issue in this case, as the court itself affirmed in its judgment of 2019. Ukraine shows similar bad faith in the case of Donbass. There too it was not interested in a peaceful solution. The Minsk agreements were based on the idea of a return of Donbass under the control of Ukraine, while respecting the desire of the Donbass population to enjoy broader autonomy. It transpires today, according to the former Ukrainian, French and German leaders who signed or guaranteed these Minsk agreements, that their only real purpose was to give Ukraine time to arm itself for a military solution to the Donbass question. Unfortunately, Kiev never intended to respect these agreements. Its only objective was to conquer Donbass by force. Kiev's actions ultimately pushed the Donetsk and Lugansk People's Republics into invoking their right to self-determination and legitimate defense, including collective legitimate defense, in accordance with the provisions of the United Nations Charter and international customary law. Of course, this case does not concern the most recent events. In fact, it only concerns the events that occurred between 2014 and 2017. Nonetheless, as Ukraine's agent has focused so much on this aspect, I will say that it is Ukraine which rejected the Minsk agreements and began the violence against Donbass. It is Ukraine which refused any negotiated solution and announced its desire, and I quote, to win on the battlefield. End of quotation. It is the Ukrainian senior officials who called people to, and I quote, kill all Russians, kill them everywhere, end of quotation. They began by killing journalists and political activists, not just in Ukraine, but also in Russia. Ukraine is constantly turning to propaganda, blatant lies, and false accusations leveled against the Russian Federation. Even before this court, on the first day of the hearing, Ukraine's agent stated, and I quote, "Today, Russia was behind the destruction of a large dam at Nova Kakhovka," end of quotation. In fact, this was done by Ukraine. The Kiev regime not only launched massive artillery attacks against the dam in the night of the 6th of June, but it also deliberately forced the water level of the Kakhovka reservoir to a critical level by opening the valves of the Dniprovsky hydroelectric plant. Of course, we all know full well who it was who pushed Ukraine along the path of destruction by transforming it into a cauldron of violence, and who it is who supports it also as a proxy in the pursuit of a legal warfare, between inverted commas, against Russia within this very same court. We appear before you today in order to demonstrate that Ukraine's application must be dismissed, because it is without any legal foundation, nor does it have any factual evidence to back it. In fact, neither the ICSFT nor the CERD bear any relation to the subject of the current disagreements between the two countries. They are simply being used by Ukraine, and I quote, as a means of bringing a broader set of issues before the court. The artificial nature of this case is also demonstrated by the fact that it includes two factual situations that are totally different, and in fact two totally separate cases. And that is why, as usual, we have organized today's oral arguments in two parts. Mr. Kuzmin will set out our objections concerning the ICSFT. Our counsel will then go into more detailed arguments, after which Madam Zabolotskaya will address the CERD, and other counsel for Russia will go into the legal and factual arguments. I would now like to ask that you give the floor to Mr. Kuzmin.
I thank the agent of the Russian Federation, and I now give the floor to His Excellency Mr. Gennady Kuzmin, agent of the Russian Federation. You have the floor, Excellency.
Madam President, members of the court, it is a privilege to appear before you in order to introduce the Russian Federation's case on the ICSFT. Ukraine's agent said on Tuesday that Russia is here to pay tribute to international law. It's true. Russia respects international law and the court as a principal judicial body of the United Nations. But does Ukraine respect the court? Apparently not. Otherwise, Ukraine wouldn't bring to this court such allegations which have no basis in law or fact. On Tuesday, Counsel for Ukraine, Mr. Kaur, said something about a big lie. There are certainly big lies involved. but they come from the Ukrainian side, which continuously attempts to deceive this court with false or incomplete information, even omitting or distorting its own evidences when it clearly contradicts Ukraine's claims. Perhaps the biggest lie coming from Ukraine is that people fighting for survival are terrorists. After the extremely violent coup d'etat and the attempt to kill the legitimate president of Ukraine, who was forced to flee the country, the Maidan regime unleashed the brutal crackdown on all dissenters, culminating in the horrible massacre in Odessa on 2nd May 2014, when over 50 people were burned alive by Maidan regime. That was not considered an act of terrorism and has not been effectively investigated to this day. The east of Ukraine rejected this hostile regime. Kiev responded by launching an armed attack against its own citizens, labeling it an anti-terrorist operation. The attitude of the Maidan regime towards Donbass may be summarized by one quote from Deputy Prime Minister Reznikov. He called Donbass a mentally ill territory and a cancerous tumor that must be cut out. Mr. Kor asked, who targeted the civilian population? The response was very simple. It was Ukraine that conducted most of the shelling in the Donbass conflict. This is confirmed by the very reports of the UN and other bodies that Ukraine relies on. The majority of civilian victims are on this side, controlled by the Donbass Republic, shelled and bombed by Ukrainian armed forces. Please see timeline of Ukrainian attacks. In doing so, Ukraine used the very same Grad and Smerch multiple launch rocket system. It claims are inherently indiscriminate weapons. Russia provided an extensive, although by no means exhaustive, list of such incidents in our rejoinder. When talking about shelling, Ukraine ignores the vast amount of evidence, including from its own side. For instance, with regard to Mariupol, Ukraine never mentions the interrogation of Kirsanov, who allegedly acted as a spotter for DPR, but deliberately supplied wrong coordinates of military objectives in the city. This is confirmed by materials presented by Ukraine in this court, as well as by the decisions of Ukraine's own courts and publications of Ukrainian media. Ukraine also constantly downplays the fact that it routinely located its armed forces in residential areas in order to use them as human shields. In the case of Kramatorsk, Ukraine concedes the presence of high-value military target, and Ukraine's own expert agrees that the Smerch multiple launch rocket systems was an, I quote, ideal tool for the job. The question only being the range of deviation of some of the rockets. Considering Ukraine itself routinely used Smerch to attack cities with many civilian casualties and never considered it terrorism, at least this is a moot point. In Volnovakha, Ukraine absurdly claims the Bugas checkpoint is not a military object, even though its own legislation clearly says otherwise, as does the presence of military personnel, armored vehicles, artillery, fortifications, and minefields. Ukraine also completely ignores the evidence that shows how the attack could have been friendly fire or deliberate provocation from the Ukrainian side. Mr. Kor also asked, who did the United Nations human rights monitors find was responsible for a reign of intimidation and terror? In fact, the very reports that Ukraine cites clearly state that it was Ukraine's so-called anti-terrorist operation that was largely the cause of, I quote, a climate of insecurity and fear in Donbass. The UN monitors say that the civilians were caught in the crossfire between Kyiv government forces and the rebels. That accusations of financing of terrorism against those supporting the eastern regions are hate speech and should not be used as a pretext for persecution. That the Ukrainian security service was engaged in illegal arrests and forced disappearances of those who opposed Maidan regime. And that the assisting, I quote, communities in the East is a new civic spirit that will help drive the next phase of the much-needed change in Ukraine. Finally, the UN monitors urged all sides to lay down their arms and engage in a peace process, which Ukraine stubbornly refused to do for 8 years, despite concluding the Minsk agreements. Mr. Kohl also asked who destroyed MH17. He seemed to think it is a rhetorical question, but it is not. What Ukraine failed to mention to this court was the presence and operation of numerous Ukrainian books in the Donbas zone on conflict on the day of the MH17 incident in the direct vicinity of the crash site. This is proven by the information from the Netherlands authorities supplied to the Hague District Court. Ukraine has failed to prove that the missile which allegedly shot down the airplane was of a new type. And Russia has proven that this missile, remains of which were allegedly discovered during the JIT investigation, belong to Ukrainian armed forces. Ukraine attempts to downplay the fact that the Ukrainian armed forces have previously already shot down a civilian airliner, killing all 78 people on board, and nobody was accused of terrorism or even brought to justice for murder. While Ukraine's own president has said that mistakes happen, we are not the first and not the last. On Tuesday, Ukraine even had the audacity to claim it was a lawful act. Ukraine's evidence that the alleged book came from the Russian Federation is extremely flimsy and replete with fakes, as we will demonstrate today. On Tuesday, Ukraine had nothing to say on this matter and chose to ignore it completely. Ukraine has also failed to prove any kind of terrorist intent with regard to MH17. On the contrary, even the Hague District Court, which otherwise displayed obvious bias against the DPR and favored Ukraine, concluded that there has been no intent to shoot down a civilian aircraft, and that the book was procured and used for air defense purposes. The Hague Court, the Dutch prosecution, and the JIT agreed that there was no evidence of terrorism or of a war crime. Ukraine's arguments hinges on the book allegedly being an indiscriminate weapon. This is an absurd claim, even prima facie, since the book is, of course, a highly sophisticated, precision-guided weapon system designed to accurately destroy specific targets. Ukraine brazenly distorts expert reports, completely ignoring the fact that experts agree that the book dealer does have the capability to distinguish civil aircraft from military, and that the dealer was originally designed to be capable of autonomous operation. Mr. Koch claimed that the book had been allegedly fired at civilian-trafficked skies. He wants you to turn a blind eye to the fact that these skies were filled with Ukraine's own combat aircrafts, constantly attacking DPR's position and bombing DPR cities, killing civilians, including women and children. Ukraine chose not to close the airspace over the zone of conflict to civilian traffic. This falls into the pattern of Ukraine actively using civilians as human shield to protect its own armed forces from rebel attacks. At the end of the day, Ukraine's MH17 case boils down to nonsense. That it is lawful and unintentional for soldiers to shoot down civilian aircraft by mistake during a peacetime, but unlawful, intentional, and a terrorist act to do so during a time of war, while believing the target to be an enemy military aircraft. This contradicts not only to the black letter of the relevant instruments, but also the interpretation of the competent international bodies, the views of legal scholars, and extensive state practice, all of which indicates that mistaking downing of a civilian aircraft in time of war negates intent for the purpose of terrorism or war crime. Ukraine's accusation of terrorism financing is all the more absurd as Ukraine itself continued to trade with DPRs and LPR in coal, steel, and even weapons. Mr. Ko said how Russia did nothing to cooperate with Ukraine. This is a plain false. Russia engaged at lengthy correspondence and consultations with Ukraine which lasted for years. However, it was Ukraine which sabotaged its own cooperation requests by wording them in vague manner that did not allow for qualification under ICSFT, by rejection of Russia's request for additional information, and by refusing to provide a list of requests relating to terrorist financing. Ukraine did not even refer to ICSFT in its MLA requests. Since 2014, Russia received around 1,000 MLA requests from Ukraine and executed almost 800 of them. Of these, Ukraine selects only 12 as purportedly related to ICSFT as evidence of Russia doing nothing. Ukraine also claims that Russia should have trusted Ukraine in its claims that DPR and LPR are terrorist organizations, instead of asking for some objective evidence of that being the case. Today we will show that there was no basis for such trust at all, as Ukraine routinely used trumped-up charges of terrorism and its financing to persecute dissenters. And none of the incidents Ukraine brings to the court are actually acts of terrorism. Finally, Ukraine itself has on multiple occasions rejected Russia's request for legal assistance, including those regarding terrorism, on the grounds of sovereignty. In some cases, for instance concerning Hizb ut-Tahrir, Ukraine openly stated that it did not trust Russia's qualification of this organization as terrorist and thus would not execute the request. The presentation of Russia's case on ICSFT will take place in the following order. Mr. Michael Swainston will present Russia's position on intent and knowledge as requirements for the offense of terrorism financing under ICSFT. Professor Khari Azari will show how funds under ICSFT do not include weapons. Professor Singhoi will clarify the interplay between ICSFT and international humanitarian law in time of armed conflict. Mr. Swainston will return to show how Ukraine's allegations concerning MH17 have no basis in law and fact. Mr. Kirill Udvichenko will demonstrate the same with regard to allegations of shelling, bombing, and killing. Mr. E will return after the lunch break to show that Russia fully complied with its obligation in cooperation under ICSFT. And I thank you for your kind attention and request you, Madam President, to give the floor to Mr. Michael Swainston.
I thank the agent of the Russian Federation, and I now invite Mr. Michael Swainston to address the floor. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honour to present to you today part of Russia's answer to Ukraine's case under the International Convention for the Suppression of the Financing of Terrorism. Ukraine accuses Russia of the serious offence of terrorist financing, and its trite law that with a serious offence the accuser must have a clear case in terms of the elements of the offence in law, and the evidence must be compelling. Ukraine's case therefore starts on unpromising ground, because generally we will see that terrorism offences require a specific intent, such as to injure civilians for a political purpose. By contrast, Ukraine relies on a mistake of targeting in relation to MH17, and Ukraine relies on alleged shellings and bombings in the course of an armed conflict. But injury in armed conflict to civilians is inevitable. It does not point to terrorism. Sadly, it happens even where scrupulous efforts are made to follow international humanitarian law, which regulates conflict. Professor Jen Zolin has pointed out the importance of that distinction between combatants and terrorists. What is at stake is nothing less than the distinction between the two. It is imperative to distinguish between terrorists who deliberately target civilians and soldiers who foresee that civilians will be killed as collateral damage while striking a military target. The former is a war crime, while the latter represents lawful conduct. And of course, soldiers also make mistakes. So a key issue in these proceedings is the mens rea required for the terrorist funding offence under Article 2.1 of the ICSFT. The starting point is what the treaties say, and here the ordinary meaning of the words in context and having regard to the object and purpose of the treaty. That's our slide 4. When we look at Article 2.1 of the ICSFT, it is entirely clear that it creates an offence requiring specific intention of the funder to fund terrorist crimes under Article 2.1a, or terrorist acts under the catch-all provision in Article 2.1b. Ukraine has cited former Ambassador Margioleto, but please see our next slide, slide 5. On mens rea, Ms. Leto agrees that intention is carefully set out and that specific intent on the part of the funder is required. I quote, "The perpetrator must have a specific intent that the funds will be used to commit crimes, or he or she must at least know that the funds are to be so used. The construction of the crime is not self-sufficient, but relies on other instruments. We shall soon see that those other instruments also require specific intent on the part of the terrorists who are funded." As regards the funder, the key word is willfully, slide 6. Professor Aust has explained that willfully was used to emphasize the requirement of specific intent in relation to funding. It doubles up on the subsequent express requirements of intention or knowledge in Article 2.1. And it's convenient to look at those requirements in Article 2.1b, the catch-all provision for terrorist acts, because that doesn't depend on the separate treaties listed in the annex. Article 2.1b sets out requirements of specific intent at 2 levels, the funder and the funded terrorists. The funder must provide funds unlawfully and willfully, with the intention or knowledge that the people funded will carry out an act intended to injure a civilian or non-combatant. And the funder must also know that this is their intent, and that the terrorists have a special purpose of intimidating a population or influencing a government or international organization. Please note that all of this is specific, direct, subject intention. The only concession to objectivity is the point that special political purpose can be derived from the nature or context of the planned act. In Ukraine's opening submissions, there was an error on this point. My learned friends focused on special political purpose and the objective element there, but then they proceeded as if it applied to all of the mental elements in Article 2.1. And with respect, that is obviously wrong. Political purpose is the only mental criterion where there is a concession to objectivity on the basis of nature of the act and context. The rest requires specific intent on the part of the funder and on the part of the terrorist. There is significance in the fact that political purpose was singled out for an objective test based on the nature and context of the act. It shows that when the state parties wanted to move away from subjective intention, they did so expressly. Article 2.3 is very informative and important on the essential aspect of intent. See slide 10. It's critical to note that the entire offence of terrorist financing is complete when the financing is provided. There is no need for a terrorist offence or terrorist act to be completed, and indeed there may be none. On the contrary, the offence of funding terrorism is made out precisely because the funder intends or knows that the terrorists will carry out a terrorist act with terrorist intent. In relation to the whole of Article 2.1, A and B, Ukraine says it would be odd if mens rea of the funder requires the funder to know the mental state of third parties, in other words, the funded terrorists. But with respect, that is not odd at all. The whole offence is complete at the point of financing. It depends on the funder's knowledge of the terrorist's terrorist intent. It is exactly that knowledge that makes the funding dangerous. So Article 2.1b requires clear, specific intention at the level of the funder and at the level of the terrorist. The same applies in relation to the funding of terrorist offences under Article 2.1a. Article 2.1a says the funder must intend or know that one of the crimes in the listed treaties in the annex is going to be committed. This is a requirement for specific direct intent on the part of the funder, and the funder must know the criminal intent of the terrorists. Otherwise, clearly, the funder does not know that a terrorist offence will be committed, because all of the relevant terrorist offences require specific criminal intent on the part of the terrorists. Let's start with the Montreal Convention, slide 12. The offence catches a person who unlawfully and intentionally destroys an aircraft in service. That raises the question, what kind of aircraft? The answer, from the plain words in context, is clear. First, the title of the convention is Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation. The acts in question must be directed against civil aircraft. The same point flows from the preamble, which you have at slide 15. Considering that unlawful acts against the safety of civil aviation jeopardize the safety of persons and property. Again, this is unlawful acts directed at a civil aircraft. In their submissions, my learned friends for Ukraine said the intention to destroy any aircraft was enough. The word civil was not in the article. But it is in the Convention, in the title, and in the preamble, and it is the entire context. Article 4.1 puts the matter beyond doubt. Slide 16. It provides this convention shall not apply to aircraft used in military, customs, or police services. We give the overall result of all this at slide 17. The convention creates an offence of specific intention, and the intention plainly relates to a civil aircraft. There must be a specific intention to destroy a civil aircraft. Now, in its reply, Ukraine says two things. First, the status of the destroyed aircraft dictates whether the convention applies. In other words, the type of aircraft is a jurisdictional point. We can wait and see whether the Montreal Convention applies, depending on what kind of aircraft is shot down. That's their first point. Second, they say that the status of the aircraft is not part of intent. But again, with respect, this is hopeless. We have seen that under Article 2.3, the offence under the ICSFT is complete at the point of financing. There need not be any actual attack. It's therefore impossible to wait for a tragedy to happen with mistaken targeting and then retrospectively to decide that the ICSFT applies because retrospectively the shooting down was within the Montreal Convention. Ukraine proceeds to cite irrelevant authority for the notion that the mens rea requirements in Article 2.1 are only jurisdictional. Ukraine cites the Tadic case, a decision of the International Tribunal for the former Yugoslavia. But that tribunal was dealing with Article 5 of that tribunal's founding statute, which says the International Tribunal shall have the power to prosecute persons responsible for the following crimes when committed in armed conflict, and various crimes are then listed. But that is absolutely not our case. The founding statute did not create offences. It set out the jurisdiction of the tribunal with respect to certain offences. Here, the ICSFT was creating the offence of terrorist financing. It did create that offence, and it did so with clear express requirements of specific intent at the level of the funder and at the level of the funded terrorists. Moreover, it's clear in context that this specific intention covers the civilian status of the aircraft. We've seen that with the title, the preamble, and Article 4. The ILC endorses that view at the highest level of international legal analysis and commentary. See slide 19. We've cited the commentary on the 1972 draft articles on the prevention and punishment of crimes against diplomatic agents and other internationally protected persons. And the commentary says, the word intentional, which is similar to the requirement found in Article 1 of the Montreal Convention, has been used to make clear that the offender must be aware of the status as an internationally protected person enjoyed by the victim. So the ILC thought that under the Montreal Convention, intention takes in the status of the aircraft. There must be an intention to destroy a civil aircraft. The ICSFT does not cover mistakes. The point on mistakes also appears from the Travaux. You see it, paragraph 5.1 on the next slide. It refers to, in some cases, such an act would be inherently destructive or harmful, and intentionally done, and not through inadvertence or mere negligence, would constitute an offence. This interpretation is also supported by the teachings of leading jurists, which you can see on slide 22. For example, Professor Trapp, the Montreal Convention requires states to prevent the unlawful and intentional destruction of a civil aircraft in service. Slide 22. No one was suggesting that mistakes in targeting should be treated as terrorism. And there's a broader point. No one suggests that military activities in the course of armed conflict should be treated as terrorism. On the contrary, Russia's drawn attention to widespread consensus that the old terrorism conventions like the ICSFT do not cover acts in armed conflict. And you see that at slide 22, and as set out in slide 23, we have ICAO comment. In the ICAO, it's been widely understood that the aviation security interests that criminalize certain acts are not applicable to the military activities they mention above. According to the ICAO, that exclusion can be made clear by amendment in later terrorism conventions, but when it happens, such a clause would be considered as declaratory in nature. The reason being there is already an implied military exclusion. And that appears clearly as well from the Beijing Convention designed to replace the Montreal Convention. See slide 24. At Article 5.1, we've got an express military exclusion like that in the Montreal Convention at Article 4. We also have the ICAO consolidating amendment at Article 6.2. And it says the activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law, which are governed by that law, are not governed by this convention. And the activities undertaken by military forces of a state in the exercise of official duties, in as much as they're governed by other rules of international law, are not governed by this convention. And the same point arises on the Beijing Protocol. Madam President, distinguished judges, all of this reflects international consensus that bad targeting, especially in the course of armed conflict, is not terrorism. One only has to look at the sadly growing list of instances where passenger planes are shot down by mistake to see that, including, as we've heard, by Ukraine. None of these instances, none, has been regarded as terrorism by the international community. And in the USS Vincennes case, which reached this court, the United States made very clear its view that the convention did not catch military activities. We've set out their submissions at slides 27 and 28. All the indications are that this view of military exclusion is generally held. On Tuesday, Ukraine tried to avoid the problem of past examples of mistaken shooting by saying that in all of these cases the shooting was lawful, whereas anything done by the DPR was not. Ukraine relies upon the judgment of the Hague Court to say that DPR members did not have combatant immunity under IHL. But with respect, the Hague judgment is very strange on that point, because the Hague Court found that the conflict in East Ukraine was an international armed conflict, and there IHL plainly gives combatant immunity. And with respect, one must consider the absurdity of Ukraine's position. It comes to this: when a state destroys an aircraft in peacetime by mistake, that is not terrorism under the Montreal Convention. But when a combatant does so in the heat and pressure of battle, it becomes terrorism. With respect, that makes no sense at all. Ukraine places bad reliance on the decision of the Hague Court on the analogy of murder. They point out that the court considers that if A intends to murder B and murders C by mistake, that's no defense, it's still murder. But there is no analogy with our case. In domestic law, A cannot kill B or C. The position is different here, under the ICSFT, where there is an armed conflict. First, there is no terrorist intent when somebody fighting in an armed conflict makes a mistake. There's no terrorist intent when the mistake is made in peacetime or in conflict. And secondly, there is a general exclusion of military activities. So that is the Montreal Convention. We need to look quickly at the ICSTB, the Terrorist Bombing Convention. Ukraine ignores the requirements for specific intention there. Again, a person commits an offence within the meaning of the Convention if that person unlawfully and intentionally delivers an explosive, etc., in a public place, etc., with the intent to cause death or serious bodily injury, or with the intent to cause extensive destruction. It's clear from context, injury and damage relate to civilians and civilian infrastructure. And Ukraine also ignores the exclusion of military acts in this convention from the scope of terrorist bombing. It's only concerned with terrorism. We see the references in the title and preamble, and there's an express exclusion of military activities in Article 19.2. The activities of armed forces during armed conflict, as those terms are understood under IHL, are not governed by this convention. So both of the relevant treaties listed in the annex creating predicate offences for terrorist financing require terrorist intent, and they exclude military activity. So how does Ukraine persist in its case? Well, first, it makes a general point to cloak its inability to deal with specific intention. It says that if specific intent is required at the level of the funder and the funded, the offence will be difficult to prove. They say that's inconsistent with a broad object and purpose of suppressing terrorism. But with respect, that's not constructive. It assumes the conclusion. The offences created under the ICSFT and the listed conventions are very serious. It's entirely appropriate that they should depend on proof of serious criminal intent. And next, Ukraine says, well, intention is not defined, so it can introduce different degrees of intention. But that, with respect, is not right. As we've seen, Ambassador Leto observed, and it's plain for anyone to see, intention is carefully set out, and it's specific and it's direct. It's set a specific intent at the level of the funder and at the level of the funded terrorist. The only point left to objective assessment is special political purpose under Article 2.1b, which can be gleaned from nature or context of the act. But that is a single instance, and it shows that when states wanted that, they used express words. And that position fits with what we have on slide 37. Other words, other definitions of intent were considered. The United Kingdom said it should be sufficient if a person provides funds in circumstances where there is reasonable suspicion that they will be used for terrorist purposes unless the person can prove otherwise. That was rejected. We should also pick up a comment from the United Nations Office on Drugs and Crime at slide 38. It addressed how to draft national law to reflect the ICSFT, and it made clear that specific intention or knowledge was required. So when national laws referred to reasonable cause to suspect, it points out at the end that there could be problems with requests for international assistance. Last 4 lines. Now, Ukraine says it does not rely on the first limb of Article 2.1, intention that funds are to be used for terrorist offences or terrorist acts, intention that they should be used. We see that at slide 39, Ukraine's reply at footnote 110. Instead, Ukraine relies on Russia's purported knowledge. But this purported knowledge, Madam President, members of the Court, turns out to be alleged knowledge of a risk, which Ukraine says is sufficient to found dolus eventualis. And that risk is said to come from 2 things. First, in relation to MH17, it comes from the suggestion that a buck TLAR is an indiscriminate weapon, creating a risk for civil aircraft. The second factor is said to be the notoriety of the DPR as a terrorist organization from which terrorist acts could be expected. You've heard from Russia's agent that that is an absurd description of the DPR, but both points are unsustainable. Before we turn to them, we should note in parenthesis that Ukraine's case is confused at this point. Ukraine recognizes that recklessness is not sufficient. See its reply, paragraph 109. Recklessness, in ordinary English, is the deliberate running of a risk. And then, when Ukraine tries to turn knowledge of risk into intent, it cites Italy against Abdelaziz, slide 42. That's relied upon for the example of an attack on a military vehicle in a market where civilians are present, and it's said by the court that there was a certainty of serious harm to civilians, and that is said to show that the act was motivated by terrorist intent. However, number one, this speaks of certainty, not risk. There is no analogy with Ukraine's case here. And secondly, there is no consideration of the exclusion of military activities in armed conflict. But anyway, the factual propositions for knowledge of risk don't stand up. First, we should note that Ukraine says that the buck was a Russian buck with a trained Russian crew. We have that and the references at slide 44. The intercepts relied on at slide 46. The observations of a journalist, slide 47. And the intercept confirming the arrival of a buck Tila with a crew at slide 48. Please understand that Russia absolutely rejects all of this case. There was no Russian buck. No buck came from Russia. No crew for a buck came from Russia. And we will see later that the evidence propping up this case is unsourced digital nonsense. But nonetheless, for the purpose of legal argument, Ukraine says there was an experienced crew. And on Ukraine's own evidence, an experienced crew should be able to distinguish between an airliner and a military ground attack aircraft. See slide 50, setting out words of Ukraine's own expert, Dr. Skorik. An experienced Buck M1 TLAR commander and operator can fairly accurately identify the target based on its parameters, jet engines, dimensions, and so on. And the court can take judicial notice that the dimensions in this case are very, very different. Dr. Skorik makes clear that the Buck TLAR has an autonomous independent mode. Slides 53 and 54 cover that. It has its own radar. AR in TLAR means and radar for targeting. And Russia's own expert agrees that a trained crew can identify military targets, and they must do so as part of the procedure for firing. That's the evidence of Mr. Bezborodko at Annex 6 to Russia's rejoinder. He again describes how Buck TLARs have got their own radar. The TLAR can track the speed, altitude, and direction of a potential target and see its shape. The crew must assess the target type as part of the procedure for engaging a target, and a Buck TLAR fires a guided missile at a specific target which has been identified as a military one. It absolutely follows that a Buck TLAR is not and analogies with nuclear weapons are precisely irrelevant. But there's another point on this. It's inconsistent with what Ukraine actually did. The agent for Russia introduced a document from Netherlands military intelligence which was asked whether MH17 was within range of a Buck when it was destroyed. Incidentally, it said no, and we'll see that later. The document with English translation is at slides 57 to 61. The important point to note from the English translation is that Ukraine had Buck TLAR units in theatre. And if we can see the table, They're exactly the same Buk-Tilar units as are attributed in the table at the bottom to Russia. This is covering the whole region. We can also see that these Buk-Tilar units were operating separately. And we know that because Dr. Skorik, Ukraine's expert, said a complete system includes a command unit, a targeting unit, and 6 Buk-Tilars. These are scattered and separate. We also know that Ukraine issued a NOTAM setting a level for civil aviation of 32,000 feet, when we know that Buks fly higher than that. How does that fit? What it shows is Ukraine knows full well that Buk-Tilars operating autonomously can discriminate. They are not indiscriminate weapons. But the crew of a Buk is human. Humans make mistakes, as Mr. Bezborodko pointed out. It's wrong, and please do read his report, to say he said it was inevitable that civilian aircraft would be shot down. What he said was, mistakes happen. He also said they were unavoidable, and he said it in the context of the USS Vincennes, but talking about surface-to-air missiles as a whole. We've heard from the agent how the Dutch criminal court did not find any terrorist intent on the part of the DPR to shoot down aircraft, and even the JIT ruled out a war crime because of the absence of specific intent. Note the language, implausible. They did not intend to kill civilians. There was no basis for anticipating, even on Ukraine's fictional case, that a trained crew would make a mistake, just as in previous instances where mistakes were made. It's convenient to mention a point on provision in this context. On its fictional case, Ukraine says there was a Russian Buk with a Russian crew. The Buk-Tilar belonged to the Russian army. It was under a Russian crew. It came from Russia. It returned to Russia. That's nonsense, but that's what Ukraine says. None of that involves provision of anything. The only thing sought to be provided was air cover against military attack. And air cover is definitely not funds, and it's definitely not any kind of asset. But I return to the second way that Ukraine says that funders in Russia had knowledge of a risk of terrorist attacks. Ukraine talks about the reputation of the DPR as a terrorist organization. But only Ukraine says that. No other state says it. No other international body says it. Ukraine relies on a report from the OHCHR to the effect that the DPR inflicted a reign of intimidation and terror to maintain their position of control. Now, there are lots of problems with that Russia has set out in writing, and please read them. But notably, the OHCHR was not dealing with terrorism under the ICSFT. It uses words terror often, including in relation to Ukraine and Ukraine's forces. And it does not say that the DPR was specifically targeting civilians with ground-to-air missiles, or with shells, or with bombs. On the contrary, it was careful to note that heavy shelling was coming from both sides, and it urged all sides to put down their arms and engage in dialogue. The OHCHR also did not criticize aid to the East. It welcomed the assisting of communities in the East. Now, the point on a trained Russian crew on Ukraine's fictional case extends to this aspect of supposed intention through knowledge of risk. Ukraine talks about the reputation of the DPR, but that's irrelevant if on Ukraine's case the Buk-Tilar was in the hands of a trained Russian crew. Because whatever might be said about the reputation of the DPR, and all that has been said is completely unjustified, nobody could expect a trained Russian crew to make a mistake and shoot down the civilian airliner. But as we've seen, mistakes happen. So, on Ukraine's materials, Ukraine has totally failed to show an intention or knowledge of funding terrorism. There was nothing that amounts to intention or knowledge under the ICSFT Article 2.1, and there was nothing that qualified as a terrorist offence or terrorist act under Article 2.1a or 2.1b. But I would like to make a last point, which meshes with an observation of the Russian agent. I've talked a lot about the fact that terrorist conventions do not cover armed conflict and military activities. And we've seen the implied and express military exclusions. Armed conflict is governed by IHL, and that is outside the jurisdiction of this court, except that it can inform the interpretation of instruments that are before the court. The reason for that lack of jurisdiction, compulsory jurisdiction on IHL, is a practical one. States do not support compulsory jurisdiction over armed conflict because in time of armed conflict there's a huge risk of propaganda and there's a real likelihood that the true facts will be lost in propaganda or the fog of war. Anticipating my later submissions, there is a very great risk that that has happened here. Those are my submissions, Madam President. I would invite you to give the floor to Hadi Azari, who is going to deal with funds.
I thank Mr. Swainston, and I now give the floor to Professor Hadi Azari. You have the floor, Professor.
Merci beaucoup.
Thank you very much, Madam President. Madam President, distinguished members of the Court, it is a great honor for me to appear before the highest international jurisdiction to represent some of the aspects of the Russian Federation's response. A significant share of Ukraine's arguments, in particular concerning the tragic accident of flight MH17 and other alleged terrorist attacks, relies on the assumption of the term funds within the meaning of Article 1.1 of the ICSFT. And this has a very wide scope, which is in fact infinite. For Ukraine, the term funds covers, and I quote, everything under the sun, unquote. And I'm going to demonstrate that this argument is untenable, but I will not take too much time because the question doesn't require a lengthy discussion. The term funds in Article 1, Paragraph 1, that appears on the screen is limited to specific categories of financial assets that have an intrinsic monetary value. They constitute forms of payment and can be freely and legally purchased, traded, and sold. Ukraine proposes only a partial reading of this article. It invites us to read only the first line of the provision and simply ignores the rest of the provision. And this is not a good faith interpretation of Article 1 of the Convention. The notion of funds must be read in the context of the whole provision and in particular in the light of specific categories of funds that are mentioned in it. In other words, bank loans, travelers' checks, bank checks, money orders, shares, securities, bonds, bank drafts, letters of credit, and documents or instruments attesting to ownership of assets or a right over these assets. All these examples refer exclusively to assets that have three common features. First of all, They have an intrinsic monetary value on their own. Secondly, they're forms of payment. And thirdly, they can be freely and legally purchased, traded and sold. Well, these are just examples, it is true, but they're all of the same kind. Is it insignificant? The answer is no. In law, nothing is insignificant, and good faith interpretation indicates clearly that the term funds is meant to encompass only instruments and financial securities, be they movable or immovable, whose nature is similar to those assets explicitly enumerated in Article 1, Paragraph 1 of the Convention. The purpose of the definition is to cover items meant to finance the perpetration of terrorist activities rather than the items that are themselves used to commit these very terrorist acts. The title of the convention expressly refers to suppression of terrorist financing. Professor Coe told you that the title means nothing. He is wrong. The court considers the title of a treaty as well to determine its object and purpose, and this is abundantly illustrated. Just to give you one example, in your judgment on preliminary objections in the certain Iranian assets case, you said, and I will just read the relevant part that is underlined. The same applies to the object and purpose of the treaty as set out in the preamble, and an indication of which can also be found in the title of the treaty. The word financing or financier appears at least 14 times in the 1999 Convention. The word weapon appears 0 times. Ammunition appears nowhere. And terms that have a military connotation never appear. And yet, Ukraine is asking you to read them in Article 1 of the Convention. But can we seriously imagine that an issue as sensitive as the regulation of weapons supply to non-state terrorist groups would be treated, as Ukraine contends, so implicitly and be so casually included in a term that only has a financial and economic connotation? Madam President, distinguished members of the court, when states decided to focus on a transfer of weapons in the convention, they did so in an explicit manner. And there are several examples of this. In our case, they decided to restrict the scope of the application to financial support provided to terrorists. However, it is the basic principle of international law that no one can impose on states obligations that they haven't consented to themselves. So the supply of weapons would be against the specific wish of the states. Parties to the convention, and this was very specifically explained during the travel that was done to when this convention was adopted. And France proposed the initial text that appears on the screen when talking about the fund. They said funds mean any type of financial resource, including the cash or currency of any state, bank credits, travelers' checks, bank checks, money orders, shares, securities, bonds, drafts, letters of credit, and any other negotiable instrument in any form, including electronic or digital form. Other states have manifested the same understanding of the term during the travel. Just to mention one, Japan. Japan said funds means any form of pecuniary benefit. The desire of states to limit this word to terrorist funding is implicit in the implementation of the convention. The Criminal Court of the Netherlands said in Article 4021, which is on the screen, a person who deliberately provides himself
or another with means or information, or deliberately collects, acquires, possesses, or provides another with objects which wholly or partly, directly or indirectly, serve to offer financial support for commission of a terrorist crime. Nul besoin.
There is no need to underscore that the object can be movable or immovable, tangible or intangible. But it will only finance terrorism if it actually serves to offer financial support for the commission of a terrorist crime, according to Dutch law. The word fund should not be understood in an abstract, vacuous manner. It is part of a whole. It is a fragment of the text, which is the Convention of 1999. In order to understand it, other provisions of this treaty must be considered because all of them are articulations of the same obligation. And in this respect, the preamble is very important because the object of the convention is expressly mentioned. The aim is to suppress specifically funding of terrorist activities rather than, in general, suppressing all support provided to terrorist activities. Paragraph 7 and paragraphs 10 to 13 of the preamble, plus the different articles of the convention, including Articles 8, 12.2, Article 13, and Article 18 of the convention, all these articles refer to financial support provided to terrorism. The ICSFT specifically aims to dry up financial support provided to terrorist organizations, and this is confirmed by the fact that Resolution 1373 of the UN Security Council, based on Chapter 7 of the Charter, almost completely contains essential elements of the regime constituted by the 1999 Convention and makes the distinction between terrorist financing and weapons provision. And they figure in two different paragraphs. The same applies to Resolution 51/2010 of the General Assembly, which is in paragraph 7 of the preamble of the convention. Many states have followed the same approach, including Ukraine, for whom weapons and terrorist financing are treated in two different articles and separate articles in the Ukrainian Criminal Code. Article 258.4 says the following, as you can see on the screen, concerning weapons, and Article 258.5 concerns financing of terrorism. And these definitions use first article of ICSFT, and this is hardly surprising for anyone. Madam President, ladies and gentlemen, members of the court, this brings me to the end of my presentation, and I would urge you to call Professor Sienho to the podium. Thank you very much.
I thank Professor Azari, and I now give the floor to Professor Sienho Yi. You have the floor, Professor.
Madam President, distinguished members and judges of the court. It is a distinct privilege for me to appear before you today to participate in the peaceful settlement dispute before this august institution, and to do so on behalf of the Russian Federation. My task is to clarify Russia's position on the interplay between ICSFT and international humanitarian law, IHL. It is indisputable and accepted by both parties that there existed an armed conflict in the Donbass during the relevant period for purposes of this case, that the existence of this armed conflict triggered the application of IHL is likewise indisputable. This, in turn, has significant implications for the present case, for the interpretation and application of the ICSFT and the conventions referred to therein, contrary to what Ukraine argues. Ukraine painted a picture of ICSFT and IHL as separate and unconnected, or in its own words, distinct bodies of international law. On Tuesday, Counsel for Ukraine argued essentially that there is no conflict between the two bodies, because only ICSFT addresses financing of terrorism. And for this reason, if a lex specialis has to be found to be applied, it is ICSFT, and it is also the lex posterior. With respect, the Council is wrong. First, the ICSFT and IHL do not both deal with financing. They do both deal with defining terror. Second, the relationship between the two bodies of law is not subject to a guessing game as the Council played, but has already been specified by Article 21 of ICSFT, which the Council did not even mention once, not even once. Article 21 expressly provides that nothing in this convention shall affect other rights, obligations, and responsibilities of states and individuals under international law. In particular, the purposes of the Charter, international humanitarian law, and other relevant conventions. This article weaves IHL into ICSFT to form an integral applicable law and gives priority to IHL. This relationship between ICSFT and IHL is that depicted in Article 32 of the Vienna Convention on Law of Treaties, VCLT, or the customary rule reflected therein. That provision states that when a treaty specifies that it is subject to or that it is not to be considered as incompatible with an earlier or later treaty, the provisions of that other treaty prevail. The ILC found a number of treaties contain a clause in which parties declare either that the treaty is not incompatible with or that it is not to affect their obligations under another designated treaty. They appear in any case of incompatibility to give preeminence to the other treaty. This led ILC to propose what has become VCLT Article 32. This relationship reaches wider than treaties, as Article 21 of ICSFT uses international by what ICSFT is not to affect. This much is confirmed by the travel preparatory of ICSFT. This approach follows closely the nuclear weapons advisory opinion. There, the court decided, in principle, the ICCPR right not arbitrarily to be deprived of one's life applies also in hostilities. The test of what is an arbitrary deprivation of life, however, then falls to be determined by the applicable lex specialis, namely the law applicable in armed conflict, which is designed to regulate the conduct of hostilities. Similarly, the Security Council has repeatedly reaffirmed member states must ensure any measures taken to counter terrorism comply with all their obligations under international law, in particular, international humanitarian law. It follows that in a situation of armed conflict, ICSFT clearly does not affect rights, obligations, and responsibilities under IHL. The ICSFT does not, and indeed cannot, criminalize conduct that is lawful under IHL. Thus, the ICRC has declared that instruments aimed at combating terrorism should never define those acts as terrorist that are governed by IHL and not prohibited by it when committed during armed conflict, such as attacks against military objectives or military personnel. Other provisions in the ICSFT and of the other treaties relied upon by Ukraine also confirm this position. Our colleagues have already discussed a few treaties, and which I will not go into now. Our reading is further confirmed by Article 2, Paragraph 1b of ICSFT, which defines offenses to include any other act intended to cause death or serious bodily injury to a civilian or to any other person not taking an active part in the hostilities in a situation of armed conflict, when the purpose of such act, by its nature or context, is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. During the treaty negotiations, concern was expressed that a broad definition of the protected persons will involve difficulties with application of humanitarian law and could lead to the situation where certain acts would be classified as terrorism when they would be acceptable under humanitarian law. To alleviate such concern, as the counter memorial points out, the interpretation of ICSFT, including the interpretation of mental elements of a terrorist act under Article 2(1)b, must take place in light and against the background of simultaneously applicable and closely related relevant standards of international law. Article 51(2) of Additional Protocol 1 of 1977, dealing with international armed conflict, must also be taken into account. That provision provides that the civilian population as such, as well as individual civilians, shall not be the object of attack, act, or threats of violence, the primary purpose of which is to spread terror among the civilian population are prohibited. The exact same language is also found in Article 13(2) of the Additional Protocol 2, which is shown to you on the screen, which I will not read. Of great importance, this form of intent was emphasized during the treaty negotiations. The ICRC commentary on Article 13(2) states, any attack is likely to intimidate the civilian population. The attacks or threats concerned here are those, the primary purpose of which is to spread terror, as one delegate stated during the debates at the conference. This rule is considered to reflect customary international law according to an ICRC study. Thus, the definition of Article 2(1)b of ICSFT should be read in conformity with the criteria for the war crime of terror under IHL. In a situation of armed conflict, only acts which have spreading terror as their primary purpose may fall under Article 2(1)b of ICSFT, and this firmly excludes incidental or collateral damage to civilians. In fact, these were also the position that Ukraine itself expressed during the negotiations leading to the adoption of the additional protocols. Ukraine does not object to these positions of its own, of course, or the Russian Federation description of them in the counter memorial. The above reading of Article 21 of ICSFT and relevant provisions is supported by the views of the ICRC commentary, the UNODC, and many scholars expressed in a variety of contexts or in the judges' folders for your references. Downplaying the role of IHL, as Ukraine attempts to do, will effectively criminalize war fighting by non-state armed groups as terrorism, to borrow UNODC's phrasing. This would disincentivize non-state actors from complying with IHL. Since the act being financed should not be considered terrorism in the first place, this will undermine the object and purpose of ICSFT, effectively rewriting it to become a convention on the suppression of general financing of non-state groups. In light of the above analysis, IHL is not irrelevant to the interpretation or application of the ICSFT. Article 1 weaves IHL into the convention to form an integral applicable law and gives priority to IHL. In a situation of armed conflict, only acts which have spreading terror as their primary purpose may fall under Article 2(1)b of the ICSFT, and this clearly excludes incidental or collateral damage to civilians. I believe this is an auspicious time for us to take a coffee break if the court so wishes. I thank you, Madam President.
I thank Professor Guy, and indeed, before I invite the next speaker to take the floor, the court will observe a coffee break of 10 minutes. The sitting is suspended.